Hi, this is lecture 6 for POL 222, U.S. legal system. We're working our way through these North Carolina cases, trying to get some purchase on legal reasoning, how precedent works, what we make of this overall, this way of proceeding, this way of thinking, this way of arguing. So I'm going to pick it up where we left off. I neglected to point something out at the end of the last lecture, so I'm going to start there. So let me share screen. Share screen. And PowerPoint. Okay, so we left off with State v. Rhodes, and in Rhodes we had a fact pattern where the husband had hit the wife with a switch 3 times. The court assumed that there was no provocation, that she hadn't done anything proximate to this beating to cause it or encourage it. We saw the court say that if these were strangers, it would be assault and battery, clearly, but they're not strangers, they're husband and wife. And then there's an elaborate argument about why, although this is not nice, it's not morally correct, the court will nevertheless decide in Rhodes that out of what it calls motives of public policy, the husband will not be held legally responsible, that this is trivial violence. It doesn't rise to the level of malicious intent. And it's better to let them work it out themselves than to have courts intervening in these kinds of conflicts. So we went through that case in some detail in the last lecture. But what I neglected to point out, and this is important to set up the next discussion. So this is Rhodes. Rhodes starts on page 12 of the PDF file. And we went through this opinion last time and tried to follow the logic of it. You would have thought the husband would be guilty because malicious intent is a limit, and the facts seem to us to show malicious intent. But the court wants to refine this analysis and frame malicious intent in the broader notion of privacy and the broader notion of family government, and draw a line that's more lenient toward husbands to use violence, so that the courts aren't intervening all the time. And they say it would, it's not that it's right. They say explicitly the husband has no right to do this. And I talked about that in the last lecture as an interesting little wrinkle on the development in this line of cases. Husband has no right, but it would do more harm than good to intervene if the violence isn't serious. That's the argument. It's a cost-benefit analysis. What is really confusing in this case, and try to follow this, at trial, the trial judge seems to have told the jury that the law was not what the law was. The law was the rule of thumb, which is an old folklore kind of thing about the size of the weapon, the circumference of the weapon. So the husband won at trial because he used a whip that wasn't too thick. And that's, these justices here in this case are telling us that's silly. That's not the law. So the trial judge got the law wrong. And at the end of the opinion, only at the end of the opinion, you see a reference to it. It is not true that boys have a right to fight, nor is it true that husbands have a right to whip their wives. And even if he had a right, it is not easily seen how the thumb is the standard of size for the instrument which he may use, right? So you see, in deference to this old folklore notion, which his honors, that's the trial judge charge to the jury was. Now, you wouldn't understand that, but this is a reference to what the trial judge told the jury at trial. This is a case on appeal. So here there's language that says, the size, I can kill you with a pencil. The size of the instrument doesn't matter. The standard is the effect produced and not the manner of producing it or the instrument used. Okay, now what happens in the next case is the next trial judge is going to take that line out of context and say, the law is about the impact on the victim, right? The physical impact on the victim. And that's not the law. The law is no permanent injury, no malicious intent. Those are the broad concepts with which we're working here. So in State v. Marbury, the next case that we want to talk about, and it's short, you can easily take a look at it. It's a couple of half pages here. Um, what happened? What are the facts? Well, in this case, the jury found by special verdict. So you see this phrase here, special verdict. You see it again in Oliver. A special verdict is a verdict where there is a procedural rule whereby the jury decides what the facts were. That's what juries do. They find the facts. They listen to the witnesses. They see the evidence. They determine what the facts of the case are. But in a special verdict, they simply bring those facts to the judge. And then the judge, who understands the law, applies the facts to the law and decides the case. That's very unusual in the American context, and it seems that North Carolina was using this mode. So the jury doesn't actually decide the case. It just determines the facts, and it brings the statement of facts to the judge, and then the judge decides the case. So the jury found by special verdict, which is not typically used in the United States. We'll get to that when we talk about the jury. That's a fascinating question, right? Like, if the jury's job is to find the facts, why wouldn't you let the jury determine the facts and bring those facts to the legal expert, the judge, and have the judge decide it? We don't do that. We generally let the jury apply the facts to the law and draw the conclusions, which is interesting in itself. But in this case, we have a special verdict. We have a husband and wife having a verbal quarrel. And he's clearly chasing her out of doors, out of the abode, and he's threatening her, and he's swinging a knife at her. And we're told that he swings a knife at her once and he misses, and then he reaches his arm back to swing again, and the imagery is quite powerful. It's of a bystander, stopping him by grabbing his arm while the knife is coming down. Well, at trial, these are the facts. But the trial judge is reading this line from the prior case about the effect produced, and again, taking it way out of context. So the trial judge is saying, well, or maybe the trial judge doesn't think it's so bad to swing a knife at your spouse. I don't know. But the trial judge is saying there was no effect produced, right? That it was an attempt of something, but if he didn't actually physically hurt her, somehow he wins. So that's the trial decision in Marbury. The husband wins. On appeal, this is the first case of the four where the court finds the husband legally responsible under the criminal law for the violence, right? And the logic is pretty simple and straightforward. It's that this is per se malicious intent. This is, if we're looking at an attempted murder, then the line that is about good faith and chastisement and controlling behavior has been crossed, and it's per se malicious. So he loses because this violates the rule. The law's not changing, arguably. This is just a radically different set of facts. The violence is more extreme and potentially quite deadly, unlike Black, where it's a physical altercation where there's the pulling and tugging and use of hands. This is a knife. So on this special verdict, there should have been a judgment against the defendant, right? So that's the ruling in Marbury. And there's nothing said here about provocation or anything. It's about, it's about how serious the violence is and how that's per se malicious. All right, so when we come down to, I'm going to skip over this excerpt from Llewellyn and the Bramble Bush. We come down to State v. Oliver. Again, we have a special verdict. We have a somewhat different set of facts. Here, a husband comes home late at night. He doesn't like the state of his breakfast. He's aggravated, he's agitated, he's throwing things around. And he determines in a kind of a very deliberate manner, from what we can see here, that his wife needs a beating. So he goes and he cuts switches. He cuts a couple of tree branches, and he's holding them in his hand, and he hits her very hard with them 5 times. And he apparently does this in public because there are witnesses, right? They're 4 feet long. I mean, really, this imagery is kind of horrifying. It's very long tree branches. He's hitting her very hard, and he stops only when the audience tells him, okay, that's enough, knock it off. And he says, I would have, if you weren't here, I would have kept hitting her. I would have worn her out. worn her out is to wear out someone by beating them was a reference in under slavery that, wear the slave out meant whip to death. So this is serious. And the opinion's quite short. We can just read it. And you're going to want to be careful about this, because what I'm going to ask you to do is think about if the law has changed, how much it's changed, how it's changed, what we know, what we don't know, and apply that analysis to a final case. That's going to be your assignment. So we can just read this. We want to read it carefully. I'll just read it. We may assume that the old doctrine that a husband had a right to whip his wife, provided he used a switch no larger than his thumb, that's the old rule of thumb idea, is not the law in North Carolina. Indeed, the courts have advanced from that barbarism. That barbarism refers to the rule of thumb, not the barbarism of hitting and violence. It's the barbarism of the rule of thumb. That barbarism, until we have reached the position that the husband has no right to chastise, beat, hit his wife under any circumstances, right? Be careful, because the court said that in Rhodes, that the husband has no right to hit his wife, and yet the husband in Rhodes was not held legally responsible. He got away with it. So what do they mean by no right? Well, are we still in the cost benefit mode of trying to draw a line between serious and trivial? Is the law changing? The statement that the law has advanced sort of signals an evolution, and there is an evolution, because in Joyner, it was certainly right for a husband to hit his wife with a horsewhip, right? So there is something going on. Okay, so there's the but there, right? The husband has no right. Now, a lot of students make a mistake of thinking, well, the rule now is no hitting ever. That's the rule. We finally evolved. You can't hit your wife anytime, no matter what. That doesn't seem to me to be the rule, because the next word is but, from motives of public policy, and in order to preserve the sanctity of the domestic circle, the courts will not listen to trivial complaints. And here's the rule of black. If no permanent injury has been inflicted, nor malice, cruelty, nor dangerous violence shown by the husband, it is better to draw the curtain, shut out the public gaze, and leave the parties to forget and forgive. No general rule can be applied, but each case must depend upon the circumstances surrounding it. Okay. Are there any firm legal rules? Does that mean that if a case, just like State v. Black, happened in 2 years, where there's a quarrel and the wife is sort of being verbally aggressive and the husband is physically violent, but not wildly physically violent, what happens in that case? Is that going to come out the same way, or will it be different? Compare the facts of Black to the facts of Oliver, and Oliver is a much more wanton, unjustifiable, severe beating. Compare the facts of Rhodes to Oliver. Well, they might be quite similar. It's an unprovoked beating with a switch. Now, we're not told a lot about the violence in State v. Rhodes. It's minimized, but we don't know. But those seem to be similar on the facts, yet they come out differently. The husband gets off and is not responsible in Rhodes, and here in Oliver, the husband's going to be criminally responsible. We think there is malice and cruelty here, says the court. And then this little closer, this little wonder what's going on. In fact, it is difficult to conceive. It's difficult. Is it impossible? In fact, it's difficult to conceive how a man who has promised upon the altar to love, comfort, honor, and keep a woman can lay rude and violent hands upon her without having malice and cruelty in his heart. Okay. Is that an announcement that the cases are going to be rare indeed, where we don't hold the husband responsible? Right? So you're left with this. And then this is like a reader, and I'm taking these materials out of a book that I would usually have people buy, and then there are always these notes and questions afterwards that are always quite fascinating. And I'll go back to this in the next video. There's one more video we have to do to finish up this unit. But the case I'm going to give you appears here, right? I've rewritten it, I've embellished it a little bit, I've added a little bit to it, but the hypothetical next case is really this one, is sort of the wife verbally bothering the husband warning the wife not to keep verbally bothering him, the husband sort of losing his temper and not hitting her with a weapon, but hitting her with his hand. What would we do with that case? Do you know what the result is? And your editors ask a really great question. If you just read this and you hadn't read these six cases, you would have a moral view of it. You would have some intuitions about it. You might have some thoughts and questions about um, the difficulties of social regulation and control in this, and how do we shape and regulate these relationships so that this violence doesn't happen. But you would have a very different perspective on it had you read it cold without reading the evolution or the development of or these prior cases, right? Once you've read these cases, then the way of handling the problem becomes quite different, right? There's a certain agenda of contention that the table is sort of set. The universe of materials we have to argue and debate is confined, right? We have to talk in terms of the two-prong test from Black, and here we're going to be talking about malicious intent and what it means or what it doesn't mean. Um, so, I mean, I think that's a very good question, and that's what your assignment's going to be when I get the hypothetical done. So I'm going to stop here, and in the next video, the last one of this unit, we'll try to take a step back and talk about this in general. I'll talk maybe a little bit about the hypothetical and how you might handle it, but also what do we make of precedent stare decisis, the system of reasoning from case to case. Okay, see you in the next. See you in the next video.